When the burners are fired up, I'm affected by the toxic fumes that come over. I can't be outside.
That's the voice of Mary Hamilton. She didn't want to be on camera. When she moved into the Mountain View Estates in Talent 2 years ago, she thought she'd be living in a quiet, relaxing neighborhood. She never expected to deal with the noises and smells of an asphalt plant right outside of her patio.
I don't have a lot of choices right now in my life as to where I live. Financially, I don't.
In 2001, Mountain View Paving Incorporation changed from concrete to an asphalt batch plant. Since then, there has been debate on whether the business can legally operate in its current location.
When land use laws came into effect in 1973, any use that was existing then is basically grandfathered, and so it becomes what's called a non-conforming use.
After complaints from residents, Oregon's Land Use Board of Appeals, also known as LUBA, is remanding a 2013 ruling that declares the plant is a lawful non-conforming use. This comes after environmental group Rogue Advocates appealed the decision.
The hearing officer determined that a concrete plant and an asphalt plant were the same use, and so he allowed, once that non-conforming use for concrete was established, he just assumed that the asphalt plant was also non-conforming.
In an issued remand to Jackson County, LUBA states while the land has potential to be non-conforming, it needs to be reconsidered based off of the way the land operated before the switch to asphalt 13 years ago.
Concrete is rock, sand, and some equipment to mix it. Asphalt obviously involves petroleum byproducts and heating that.
Meanwhile, Hamilton says she wishes the business would be seized until a decision is made.
If that's the way Southern Oregon law is, I wouldn't like it, but I could accept it.
Covering your news and talent, Ashley Carrasco, News 10.